First Appellate District of Ohio. The Honorable Marilyn Zides presiding is now in session. Please be seated.
Good morning. I hope everyone's dry. It's been a really wet weekend, hasn't it? It's that fall rain, you know, we get it in the spring and then it comes back in the fall. Welcome to the First District Court of Appeals. Today is Monday, October 30th. We have one case on the docket and it is scheduled for oral argument. It is case number C230076 in Re J.A. If attorneys can please identify themselves and their readiness to proceed.
Good morning, Your Honor. Margaret Kane and Jessica Moss, on behalf of the appellant J.A., we are ready to proceed.
Thank you. Nice to meet you this morning.
Paula Adams on behalf of the state of Ohio.
All righty. So Attorney Kane, if you want to come up to the podium. Would you like to reserve time?
Yes, 3 minutes, please.
All righty. And you can start whenever you're ready.
All right. Good morning, Your Honors, Counsel. May it please the Court. Margaret Kane and Jessica Moss on behalf of the appellant J.A. In some ways, this case is challenging. It's challenging because it involves allegations of inappropriate sexual conduct between two young children, KT, who was nearly 5 years old at the time of the alleged incident, and J.A., who was only 11. In other ways, however, this case is simple. The legal issues before this court today are straightforward. In J.A.'s brief, we assert 3 assignments of error, which I will argue out of order this morning, focusing primarily on sufficiency of evidence, which is assignment of error 2. The juvenile court erred in adjudicating J.A. because even when the evidence is construed in the light most favorable to the prosecution, it is insufficient to establish the element of force under RC 2907.02. In other words, even if this court were to accept all of KT's allegations as true, they are insufficient legally to support J.A.'s adjudication.
Now, the trial court made some factual findings with regard to J.A. and the victim, and I'm going to paraphrase it. It was to the effect that that the victim wanted to play the video game, didn't want to engage in the sexual conduct, but did so in order to play the video game. So how does that factor in at all into the element of force?
Yes. So the way that factors in is in finding the element of force, the juvenile court relied on an inapplicable reduced standard of force that was articulated in the case State v. Eskridge. In that case, the Ohio Supreme Court found that where a father had been accused of raping his 4-year-old daughter, that evidence of minimal uses of force or subtle psychological force was sufficient to establish the element of force in those cases. In cases where there is not a parent-child relationship or a similarly analogous relationship of authority, that reduced standard of force is not applicable, which has been determined by both the Ohio Supreme Court and numerous appellate courts. So, thinking about the fact that you just pointed to, Your Honor, that would be an example of subtle psychological force, which is not applicable in the context of an allegation involving 2 children.
Well, it would be also coercion. And so you're talking about a very young child as being the victim. And then also you're talking about the alleged perpetrator also being under 13.
Correct. And so we actually have a couple of cases in Ohio that provide a lot of guidance on this point. So there are 2 cases out of the 8th District. In Re LRF is one of them, where there are some factual similarities, where the court found that subtle psychological coercion or bargaining is one other way that courts have articulated that type of behavior, is not sufficient to establish the element of force under RC 2907.02, A2, where the case involves 2 children. So in Re LRF, that was a case involving a 10-year-old child and his 6-year-old cousin. And in that case, the defendant allegedly took his cousin into the basement, which was a secluded area of their grandmother's house, and asked her to perform oral sex on him. And he threatened to tell the younger child's mother that she kissed a boy unless she complied. Even though that involved threatening, sort of psychologically coercive behaviors, the 8th District determined that that was insufficient to establish the element of force where it involved two children who, where there was no relationship of authority. And in that case, the court determined that in that context, there needs to be evidence of either physical force or an explicit threat of physical force in order to...
In that case that you're citing, were both children under the age of 13?
Yes. In that case, the defendant was 10 and the victim was 6. So very close in age to KT and JA in this case. Even in another... Yes.
You're talking about the age difference. This is a little bit more of a significant age difference, 4 years old and 11. Can we look at that among the other factors when we're looking at whether there was coercion?
So I would say that it would be inappropriate to look at that in terms of whether or not there was coercion, because the General Assembly specifically partitioned off part of the rape statute to deal with age. So under 290702A1B, that's our statutory rape statute or provision that talks about children under 13 being unable to consent. That age difference, as it comes into play here, especially with two children under the age of 13, I don't think is relevant to the analysis of whether or not there was use of force.
To what extent does the child's testimony factor into the element of force? Should we be looking to how KT himself described this encounter and whether he expressed any aspect of being forced, coerced, the absence of choice in his testimony?
So certainly the child's testimony, especially under a sufficiency of the evidence review, would absolutely come into play in terms of assessing whether or not there was force. In this case, KT never alleged that he was hurt. He never alleged being afraid. He indicated that he agreed to participate in this quote-unquote challenge because he wanted to play Roblox. And that is not sufficient. Even if we look at In Re DB, which is the seminal case dealing with whether or not a child under the age of 13 can be adjudicated for rape under A1B, the statutory rape statute, the court also looked at the facts of that case under A2 to determine whether or not there was force sufficient to establish rape under A2, forcible rape. And in that case, the allegations were that DB, who was, I believe, 12 years old at the time, had asked some of his friends to perform various sexual acts, including anal sex, under the pretense that if they did this, then he would let them play a video game, which is very similar to the allegations here, where the allegation is that KT wanted to play the game Roblox and asked Jay to do so. JA allegedly said, you know, you would have to complete a challenge first. And so under the case law right now, that, especially given the young ages of both of these children, would be insufficient to establish force. As to some of the other factors that the juvenile court looked at and why those also do not constitute force for purposes of adjudicating JA, I want to point to the section that talks about JA allegedly pulling KT's pants down. So that allegation, standing alone, is not sufficient under the case law to establish force either. So removal of clothing has been determined by numerous appellate courts throughout Ohio to be potentially indicia of force, but standing on its own is not sufficient to establish the element of force. So in this case, that would be the only allegation that there would be any indicia. And there are many courts, even in sleeping victim cases, that have determined that manipulation of clothing standing alone without something more is not sufficient to establish force. Moving on to, unless there are any other questions relating to Eskridge and the standard of force in cases involving two children.
Can you address the relationship? Eskridge does direct our attention to the relationship between the victim and defendant. Can you speak to that?
Absolutely, yes. So in Eskridge, the Supreme Court was speaking specifically about the relationship between a parent and a child of tender years and the unique relationship of coercion that exists between a parent and child. And Eskridge has been clarified and limited by the Ohio Supreme Court and numerous Ohio appellate courts to only apply in the context of that parent-child relationship or in a similarly analogous relationship of authority. So, for instance, a grandparent and a young child, or an aunt or an uncle, a step-parent. However, it has never been applied to a case involving two young children.
Do we know whether J.A. and K.T. had previously spent time together, or whether K.T. would have had an expectation that he would continue to spend time with J.A. after this encounter?
So the relationship between K.T. and J.A. specifically, K.T. went to J.A.'s home every weekday during school hours because J.A.'s mother was his babysitter. J.A. was almost always at school during the times that K.T. was present at his home, but the families did know each other for a long period of time and had a long-standing child care relationship, J.A.'s mother caring for K.T. Generally speaking, J.A. and K.T. did not have much contact with one another at all, and there was no established relationship where one could have thought that J.A. had any sort of caretaking role. In fact, when Hamilton County JFS investigated these claims, they determined that J.A. and K.T. had a peer-to-peer relationship. It was not a caregiving role. J.A. was an 11-year-old boy. He was an 11-year-old boy in school, happened to have the day off. That's the only reason he was home that day. And so that's sort of the nature of their relationship. In addition to there being insufficient evidence of force in this case to support the adjudication of J.A., there are also issues with the trial court's ruling regarding allowing K.T. to testify. Under Ohio law, a child under the age of 10 is presumed incompetent to testify.
You have about a minute.
In this case, when there is a child who is under 10, there must be a voir dire. If the voir dire is deficient, then the child is presumed or is determined to be incompetent. Now, the appellate courts have determined that if voir dire is insufficient, that the child's testimony may be developed such that competency can be established through their trial testimony. In this case, we would ask the court to find that there was insufficient evidence of KT's competency brought out through the initial voir dire, and based on the internal inconsistencies.
And to that point, I noticed that it seemed as if during the voir dire there was no questioning of events in proximity to the event at issue.
That's correct. So even in questioning KT about more recent events, he struggled during the voir dire to be able to give clear answers to those questions. And then there was nothing in the voir dire that dealt with his ability to recall events from the time period, which was a year and a half prior. So KT at the time that he testified was 7. At the time of these events, he had not yet turned 5. And so there was not anything pulled out. And so I would argue that the voir dire was deficient for that reason. And so it was unable to establish KT's testimony. And because of that, the inconsistencies internally within KT's testimony at trial were unable to cure the deficiency that existed through the voir dire, and therefore KT should not have been permitted to testify, and that should not be considered.
Ms. Kane, assuming that we agree with you, what is the appropriate remedy? Do we simply strike KT's testimony and remand for new trial? What would we do with that?
Yes, so prior cases that have dealt with this issue have remanded for trial, so stricken the testimony of the child. There was one case where the child's testimony was considered cumulative, or there was a lot of other evidence in that case, and so it was deemed harmless error. But in this case, it really hinges on KT's testimony, and so we would ask that the court reverse and remand if you find that KT was improperly permitted to testify, and remand for a new trial.
Could this case be tried without KT's testimony?
No, I don't believe it could.
Is there a possibility that KT could become competent to testify in the future?
So I think, yes, if this were to be remanded for a new trial, then it would be possible that the trial court could conduct a new voir dire. He's still not 10, and so he's still sort of under that threshold age, but they could do a new voir dire and determine whether or not he's competent and proceed with a trial if he is found to be competent at that time.
So it's possible in theory that his memory could have crystallized or improved, or that the deficiencies, assuming we agree with you, that the deficiencies in the record could be cured at a later date.
Potentially, yes. Although I will say we would be asking this court to find that the evidence before it today was insufficient to meet the standard set forth under 2907-02A2, and so we would actually be requesting a full discharge of the adjudication of JA. If there are no other questions?
Thank you.
Thank you very much, Your Honors.
And I am reserving your 3 minutes.
Thank you.
Morning, Your Honors.
Good morning. How are you?
Good morning. Good morning. May it please the court.
I don't want to throw you off script, but I'd like to start where we ended, if that's okay. I have a question with regard to the argument of competency. Do you recall the objections on this case?
Yes, Your Honor, and I think that their challenge is, from what I understand, the ability to recollect.
Right.
And I think...
And the question was that raised on the objections?
I think they made just a general objection across the board, if I'm not mistaken. But in response to that, I think that what was very clear and what was presented to the court is that it wasn't necessarily he didn't have the ability to recollect. He didn't want to talk about it. And I think that's very clear in the record, both at the voir dire for his in-camera competency hearing, as well as throughout the trial.
Well, counsel, that would be true as to the incident itself, but that wouldn't be true as to things like his birthday in a previous year or something, right?
Right, and I don't think there's any indication that he didn't know his birthday.
He couldn't remember what he did for his last birthday.
Right, and quite honestly, I think in certain environments, I mean, a birthday to one of my children is a big deal, and they may remember every little detail of that. You know, there's a theme, there's gifts. Not every child has a birthday celebrated that way, so I don't necessarily think that that's a fair way to assess that memory. And that's a common way of asking that, but I don't think just because that particular factor isn't going to indicate that he's not competent. So I think if we look at this as a whole.
But there were, from my reading, there were no questions really in the in camera about what he recalled. At least he didn't. If there were, then he didn't answer them.
Well, and that's just one prong of what the court is looking at when they're assessing competency. So I think that if you look at, they did ask him about, his grade, his teacher, those sort of questions that, he's, at the time of trial, I can't remember how old he was. So, being in school was a newer thing for this child.
But doesn't the trial court have to consider all of the Fraser factors?
All of the factors, but I think that these questions are wanting the court to hone in on that one factor. And again, it's an abuse of discretion standard, so I think you have to look at not one factor weighs particularly over the other. And again, you have to be sensitive to the circumstances, the young age, obviously, and the scenario surrounding. And again, like I said, I know that the birthday one and what gift or what was your cake or those seem to be common questions, but that's not just because a child doesn't respond or doesn't remember those. That doesn't mean that they don't have the ability to recollect. It could be that there was nothing memorable for that particular birthday for that child. So I don't think weighing that so heavily would indicate that the trial court abuses discretion.
I'm not just focusing on the birthday. I'm talking about during the in camera there was no recollection of what happened, what allegedly happened.
Well, I don't think that that's necessarily the appropriate time to get into the facts of the case during the
right,
but
I guess there were really no questions or no answers about, because it's the child's ability to receive accurate impressions of fact or to observe acts about which he or she will testify, be able to recollect those impressions or observations and communicate what was observed. And it's my understanding, and correct me if I'm wrong, is that if that is not part of the hearing about whether the child is competent to testify, it can be cured in trial, but if it's inconsistent, it's not cured. Am I off on that?
Well, I don't think, I guess I would disagree with inconsistencies. I think it was appropriate at the time. Again, it was
I'm
very
asking
clear.
if that's what the rule is.
Right, no.
Okay.
And I think, again, in consideration of the circumstances here, the child not wanting to discuss what happened. And he was very, very direct. I mean, if reading the trial testimony, I don't want to talk about that. That's something that's a memory I don't want to bring up. Very clear. So there was that particular challenge. So I don't think that questioning him ad nauseum during a voir dire, bringing that up. He knew what he was there for, obviously. I don't think that was required to get past the threshold of competency. Again, this is an abuse of discretion standard, so I think that the record as it's set forth is sufficient for there to be for this court to affirm the finding of competency.
Well, the argument was that although the voir dire may have been insufficient, and as it stands is not enough to determine that there's an abuse of discretion on competency, but that the testimony during the proceedings created the issue on competency, and that's where the abuse of discretion arises.
Well, and again, I think the context when we're fast forwarding in trial, that he wasn't competent. It was he didn't want to. So there were those challenges that they got beyond those challenges of him not wanting to testify to those, and that was apparent with them bringing out the videos and stuff from the Mayerson Center. So I think that fast forward to the trial, I do think that was cured, and I think.
Can you
in this
address,
particular
counsel, can you address why What about KT's testimony at trial would have cured the presumption that he's incompetent to testify, coupled with what the defense is arguing are some pretty glaring deficiencies in his ability to recall the relevant time period?
Well, I don't think that there was ever any indication that he couldn't recall the time period. He knew this was his last time that he had ever gone to that home. So, the date was never an issue. Again, I think it was a unique challenge of he didn't want to talk about it. And I think that's what they overcame in the trial. I don't think that he didn't necessarily recall it. He just didn't want to talk about it during trial. And I think that they did get beyond that with the refreshing his memory and the videos and stuff. And one thing that just stands out is when the prosecutor says, well, I'm going to show you this video, he says, hey, wait, where'd you get that video? So he, obviously there was some recollection. I mean, I think that's what that stands for. If I could then move on to the sufficiency, I think that this court has brought up points that I would like to make. No one's, I don't think the trial court at all relied on the relationship here, so the estrage, I don't think that's anything that we should consider here. No one thinks that he was in a position of authority, but I think that when the trial court's finding that there was circumstantial evidence of force relay to the age difference, as well as, and picture an 11-year-old and a 4-year-old, the size difference there too. And I think that the circumstances of which he went upstairs, there was the house rule, you're not allowed to go upstairs. So he was, I think in his words, he sneaked me upstairs. He took me up there so no one could see. And then he thinks, okay, yeah, I'm being sneaked up there to go play Roblox. That was, kind of seemed to be his indication that that's the only reason to go up there is because that's what's up there. So I think, too, then when we look at the coercion, if you will, there are two incidents here. There's an anal, there's first the oral, and the child's testimony was, I didn't like that. I told him I didn't like that. And then that's when it switched to the anal. So I think that both of those, the force involved in both of those, just, the age difference, the size difference, all of that went into play for the trial court to find that there was sufficient circumstantial evidence of force in this case.
Can I clarify that? So to be clear, you're saying that the Eskridge standard with psychological force inherent in some kind of relationship doesn't apply here. And instead, we should look at the circumstantial evidence of what might be physical force in the description of what happened.
I think that's what the trial court's finding indicates. There was
Thank
never
you.
any indication that it had to do with the relationship.
Thanks, that's really helpful. Thank you.
And if there's no further questions, thank you.
Can you talk about the DNA evidence?
I'm sorry.
I'm sorry. It's something that hasn't been really, can you talk about the significance, if anything, of the DNA evidence? Because one of the last questions that was asked to Attorney Kane was, if we were to agree with you, what would be the net result of that? Is there enough, nonetheless, to support the outcome of the case?
Yeah, that's something, and
So let's say we were to say, hey, the testimony, the victim was not competent, so the testimony shouldn't be considered.
Right, and I don't know that, because I think that there would have to be another voir dire of him for his competency. I don't think that would be completely like that, you get one shot at showing that someone under 10 is competent. If it goes back for new trial, I think
So what you're saying is the remand would be the proper outcome of that?
I think that if the competency were the issue, that definitely, yeah. But yeah, the DNA evidence obviously is quite substantial, and that's a significant factor. Trying to explain away DNA from laundry is, I think that was their their response to the DNA, but I think that was, you know, pretty cut and dry that the delinquent's DNA was found in the child's underwear. So I think that's a significant piece of evidence.
If I remember correctly, the defendant, or the delinquent child, had an expert testify that it's possible for the DNA to transfer in the laundry. So is this really just a matter of believability, or
I think obviously,
or disagreement with the expert?
Some of those go to credibility, to the weight of the evidence. So obviously that's a credibility assessment. So I don't think that there's, you know, any way around that. But yeah, I think that was just a, you know, an explanation. I don't know, and again, that came from the delinquent child's mother was the one who had presented that scenario.
Was it refuted that she sometimes did their laundry together?
I don't know that that there would be any way to refute that. That didn't come out in the testimony, but I think that that again, that was obviously a very strong piece of evidence.
Was the expert's testimony refuted?
I don't recall there wasn't a particular assignment of error with regard to the DNA evidence, aside from the sufficiency, so I don't recall.
Okay, thank you.
Counsel, the DNA, if I'm remembering correctly, was both a weak sample and also came from saliva as opposed to some other kind of bodily fluid.
I don't remember the particulars of, or that it was even able to be identified with that it was saliva. I don't recall that.
I believe it was like I'm probably going to butcher the scientific term, but like an amylase compound, which is only found in saliva. And if that's the case, does that align with KT's description of what occurred?
I think obviously there was like I said, the first incident was an oral incident, and the second one was anal. So I think that obviously there was there would be saliva involved in the oral act. So I don't think it's inconsistent at all. So, but certainly a significant piece of evidence. But with regard to, you know, how it got there, again, I think that is a credibility.
Well, I mean, there would be saliva of JA involved in the oral act. I'm sorry, of KT, that is. But wasn't it JA's?
I'm awful with the initials, but the child's, and I don't know that who's, I'm getting my initials mixed up.
So KT is the victim, JA
yes.
is the
So KT's
accused.
Saliva would be on JA's. So I don't, you know, that is something that, you know, certainly there was no questioning regarding that.
Yeah. That's if it is saliva, yeah. And let's put aside whether it's saliva or not, if we can, for a second. As I understood it, the DNA was on the inside of the front of KT's underwear. I believe I'm recalling that correct. Is there any significance to that in relationship to the alleged offense and what it was that KT had recollected had occurred?
Right. I think, you know, an 11-year-old's DNA being found in a 4-year-old's underwear, anywhere that would be, I think that's a significant piece of evidence. I don't recall the, you know, particulars of where.
Was there any challenge at the trial court as to the location of the DNA cutting against the veracity of KT's story or cutting against the
Absolutely not.
The
No, I think
sufficiency.
it only bolsters the, his, corroborates what his explanation of what, the explanation of what occurred to him. I think it does corroborate it.
I don't know if there's anything
Question? No,
further from the panel.
Okay.
All righty, thank you. Thank you for coming back up. All right, so you have your 3 minutes.
Okay, great. So I'll try to run through quickly. So I just wanted to clarify for the court regarding the competency issues. So under State v. Douglas, which is a 10th district case, the court found that where the trial court fails to elicit sufficient information during the voir dire to establish each of the Fraser factors, it is an abuse of discretion to allow that child to testify. However, if the child's testimony cures those deficiencies, then that can allow the trial court to establish competency through the trial testimony.
Here's my question on that, though. As I recall the objections, it seemed to center on KT's ability to distinguish truth from non-truth. Was this raised? Was this issue of competency raised within the argument of competency as opposed to the argument of sufficiency?
So on the objections, the issue of competency was raised. I believe you're correct. I think that the trial attorney who wrote the objections and made the oral argument regarding objections did focus on his appreciation of truth and falsity, though he also did indicate, not quite in a straight line, but indicated that the inconsistencies in KT's testimony also suggest that competency was never truly established, and noted that during the voir dire they did object vociferously to KT being permitted to testify because they felt that what had come out in the voir dire was not sufficient to establish his competency.
Because if it wasn't raised at the objections with relationship to competency, then wouldn't it be waived? Can it be raised before us now in the context of competency?
So I think that because the issue of competency was raised and because there were objections to whether or not the voir dire was established his competency, I think that preserved the issue for the court to consider under the Fraser factors more specifically. Although I do acknowledge that the exact articulation was a little bit different at the objection level as opposed to the appellate brief that we submitted. So I'll defer on that one.
I appreciate you answering the question.
Yeah, absolutely. And then just to quickly run through, so there were a lot of inconsistencies in KT's testimony, and so some of those included inconsistencies about the allegations themselves. At first, KT indicated that the only thing that happened was that there was oral sex. After a line of questioning, he then clarified, okay, wait, no, there was actually this other thing that happened. There were inconsistencies about whether his clothes were on the whole time or not. Inconsistencies about who he told, how many people he told about the incident. And so I would say that those things indicate that the deficiencies were not cured. And then briefly, I would like to just move back to the issues around force and sufficiency of the evidence. I'd like to note that the trial court explicitly relied on State v. Eskridge in its decision. It cited it directly, and also in talking about the circumstances that support its finding, it talked directly about KT and JA being having an age gap and being different sizes as part of its reasoning, and that came out a lot in the prosecutor's arguments as well. both in closing arguments and again on objections.
I mean, looking at the trial court entry, it talks about the juvenile was much older than the victim and in a position of power over him. And then it talked about taking KT to a secluded area of the home in the pretense of completing a challenge in order to play a video game. So the state's argument would be, well, as I understood it, would be, well, there was other evidence in the record that the trial court would have considered as well. So this alone doesn't make it outcome determinative as to what the trial court considered in making the determination of force.
Right. So I think my response to that is that the circumstantial evidence on which the court relies is not sufficient to establish force, except for in cases where there was a parent-child relationship or similarly analogous relationship of authority. So those sort of secondary factors are aligned with what would constitute potentially sufficient force under the Eskridge standard, but those incidents, as borne out in the case law, do not support a finding of force when Eskridge is inapplicable. When Eskridge is inapplicable, the state has to prove beyond a reasonable doubt that the victim's will was overcome by duress or fear through the use of physical force or the express threat of physical force. We don't have that here. And I would like to note, just in terms of the sneaking upstairs, there was testimony that KT had attempted to go upstairs on his own several times that day. There was a playroom upstairs. It was off limits, but it was something that he really wanted to do. Grandma testified that he had to pull KT off the stairs 4 times throughout the course of the day. And then also the state noted that because there was oral and because there was this allegation of anal sex, that would be sufficient to establish force or something akin to that. The case law is very clear that the force necessary to commit the act itself is not sufficient to prove rape. So even if this court believes that these allegations are true, if the court accepts that what KT alleged is true, it's still not enough to prove that element of force. And that's really crucial. And as to the DNA...
So to the element of force, even if there's an issue with the competency of KT, does the DNA factor into the element of force, the DNA evidence?
No, the DNA evidence would not factor into the element of force. At most, it could potentially corroborate that some sort of contact happened, but it does nothing to establish force. And I'll also just note, this goes more to manifest weight, but the DNA was a weak positive result for amylase, which is predominantly a component of saliva. No semen or blood was found on any of the items.
Is that part of the record that is a component of saliva?
Yes, it is. And it was actually the state's expert who testified about the DNA. And so the state's expert acknowledged that DNA can be transferred very easily. And while it would be potentially uncommon for DNA to transfer inside someone's clothing through incidental contact, there is this possibility where you have these ongoing contacts, shared bathrooms, shared living spaces, watching the same TV, having laundry done together. All of these things suggest that the state has not proven beyond a reasonable doubt whether or not that DNA evidence establishes that this sexual contact even occurred. But again, that's going to the manifest weight. If we are just looking at, we're going to construe everything in favor of the state, looking at the DNA, at most that would just establish potentially that some contact occurred.
And counsel, KT's version of events does not explain how J.A.'s saliva would have wound up on his underwear, does it?
No, it does not, Your Honor. So the allegations are that KT performed oral sex on J.A., and that J.A. placed his penis on KT's rectal area. And neither of those explain how J.A.'s saliva would end up in KT's underwear. And so the DNA evidence in this case does not corroborate the specific sexual conduct allegations.
But can we make that determination? Isn't that something that should have been argued below and the record should have been established below? I mean, you're asking us to make a factual determination with regard to that.
I will concede that that was not argued below, yes.
But counsel, isn't there testimony in the record that challenges the DNA evidence?
Yes, so there was there were challenges regarding the DNA evidence that were brought up at trial and in the objections. Again, articulated slightly differently than how I argued it in our brief, but yes, that was before the court. The trial court was the reliability of the DNA evidence, what it actually would have proven, and whether or not, because they went into specific testimony about other ways that the DNA could have arrived there, and so that was in the record, yes.
And in an insufficiency challenge, are we looking at all of the evidence that was presented, including the DNA?
Yes. If there are no other questions?
Thank you.
All right, thank you very much.
Thank you. Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision, and we wish everyone a wonderful afternoon. Thank you.